All right, call this work session to order. We'll be discussing AK Alchemist. Let's go around the room and identify ourselves for the record, starting with Ms. Wynn-Pearson.
Becky Wynn-Pearson, Municipal Attorney.
Forrest Dunbar.
Christopher Constant.
Okay.
Anybody else there?
No, that's fine. I'm sure
Here, I'm
there'll
just observing.
be. Yeah. I wonder, is Mr. Gates required for this discussion? Is he sort of a party to this? Is this mostly between you and the?
He and I have been handling this collaboratively, so I think I'm equipped to report on our collective position in terms of where we are right now.
Okay.
He certainly has been an equal player in working with me on setting the process and making sure that we're completely on the same page with how we move forward with this applicant.
Okay. Well, why don't you begin, Ms. Wynn-Pearson, give us an update. Also know for the record that we have been joined by Mr. Croft. Thank you, Mr. Trainee.
Certainly, Mr. Chair. So the purpose of this work session, which will probably be very brief, was really just to provide you with a collective quick briefing on the status of the AK Alchemist conditional use permit process and have the opportunity for a bit of discussion of where we are, or questions if needed, before we get to the assembly meeting on Tuesday, because the plan has changed in between the original intent was to have an actual public hearing on the merits of an application for extension on Tuesday. That's not what's going to happen at this point. So this is what I wanted to brief you all on. I also did notify counsel for AK Alchemist that we'd have this work session if he wanted the opportunity to speak directly with the whole body in an appropriate, not ex parte manner. And I don't see him in the audience, but if he arrives, the intent was to allow him that opportunity as well.
I saw the Lieutenant reminded him of this meeting, so he's been reminded again.
Excellent. Okay. So, as we've previously discussed, the reason this one is complicated, it's the first and only temporary limited conditional use permit for an alcohol-related establishment in Anchorage, so there's no specific code provision that says what happens when the temporary limited permit expires and the applicant wants to do something else, continue, extend. So the permit itself expired on March 31st, 2018. Planning wasn't required to give prior notice, but did on March 30th. That led the applicant to shoot a last-minute email in asking for an extension. You all then approved AR 2018-111 on April 10th, which extended the conditional use permit for 60 days and set a public hearing date for May 22nd. Mr. Gates and I then started working on piecing together what the process would actually be for this public hearing and for the consideration of an extension or modification of the conditional use permit. I've passed out the two letters we sent to counsel from AK Alchemist, which lay out the first letter is actually at the back. It's an attachment to the second letter, which sets out the full process, the applicable portions of the code, the deadlines they needed to meet. The second letter on top is a follow-up after they turned in their application materials. The short story is that the process is governed by the administrative hearing provisions of Title III, the conditional use permit modification and public notice provisions of Title 21, and then some unique requirements of the original AR 2015-261S, which is the structure that you all created in 2015 when you approved the original conditional use permit. So we cobbled those all together, sent them a list of deadlines. The first deadline was a May 1st deadline, which was a short turnaround. They got the written notice from me on April 26th. I did make sure to clarify that deadline to Mr. Coffey when I spoke to him the night before I gave him this letter. I sent him a follow-up email just to make sure he was clear on who he needed to speak with at planning to go in and get that notice. And his client, while he did turn in application materials by May 7th, he did not complete the public notice process by May 1st. There's a 21-day notice period required for a modification to a conditional use permit. It's the mailing to the neighbors, posting on the site, etc. That wasn't completed. So we can't proceed with a public hearing on May 22nd because the required public notice was not given. They did submit application materials on May 7th. They're looking for a number of changes to the conditional use permit, including how the mobile food units are treated, and also asking for an extension to a permanent conditional use permit as opposed to a time-limited one, a number of other things as well. So where we are right now, and the AR that will be on the table in front of you on Tuesday is AR 2018-162, which I've also distributed a draft of. What this does is it allows the conditional use permit to expire by its terms on May 31st. It doesn't terminate it, it just says we're not further extending it until you come back before us for public hearing. Sets a public hearing for June 26th, which is the soonest you can have them on the calendar and meet the 21-day notice threshold.
You can't do it on June 12th?
No, it's not. It's less than 21 days from now. Because you have to set the public hearing first before you can public notice it. So you haven't set a public hearing until you've done this.
Isn't it exactly 21 days? 'Cause it's,
20, I guess it's exactly 21 days. I think you wouldn't be able to public notice the same day. You'd have to do it the next day. So, 26th.
I want to pause for a second, just know for the record, we've been joined by Ms. Domboski and Mr. Gates. Mr. Peterson, were you already on the record before? Okay. Mr. Rivera. Okay. Mr. Trainee, and then we'll continue.
So are they currently serving alcohol?
They are currently serving alcohol because currently not without a license. You extended the conditional use permit. What your last resolution did was extend it and allow them to continue to serve.
What day?
Until May 31st.
Okay. Thank you, ma'am.
So as drafted, this allows that to expire on May 31st. Mr. Bosky, do you have a question?
Ms. Domboski?
I was just going to wait till you're done.
Okay.
So, I thought our intent by extending it was because we thought we were going to have the public hearing May 22nd.
Yep.
So within your resolution, I don't see what the problem is. Is the Department of Law or the administration opposed to us extending the conditional use permit to like the end of June so we can at least have the public hearing? Because, you know, I think a lot of people are saying, well, we haven't had any problems down there, or thinking, why not just let them continue on with their operations to go through this process?
You certainly can. I mean, we drafted this after Mr. Gates and I touched base with the two sponsors of this, and we were of the mind that we should proceed in this way. You can certainly amend it if you want to and allow for the conditional use permit to remain in place. You could schedule a public hearing later. You can't schedule one any earlier, but you could do it later. Again, you're certainly welcome to amend it. You could also, if you don't vote in favor of it, then the conditional use permit just expires May 31st and it's done.
So I have two questions. Question number one would be, what would the impact to operations of this entity be if the conditional use permit expires?
They can't sell alcohol until
That's
they,
what I
yeah.
assumed. The second was, I just want to make sure I'm not misunderstanding what happened before, because it was my thought, and I'm just re-verifying this, it was my thought that the reason we extended it to May 31st was specifically so we could get the public hearing in and do everything at once. So, did I misread that?
No, that's what we did. They missed a deadline. They
No.
were supposed to, in order to have the May 22nd public hearing, we told them they had to do the public notice process, which is, by May 1st, and they didn't do it.
Right, I hear what you're
Yeah.
saying. So, I personally would ask Dean to prepare me an amendment so I can extend this to June 31st, because I think it'll just.
Mr. Gates, you were in the queue.
Yes, I just wanted to add, I think that in terms of having the public hearing, sometimes when public hearings are required, we're able to waive that hearing of notice requirements and have a public hearing notice. In this kind of instance, where the public notice is required to be posted on the property and mailed to the property owners, the rights of the public and the surrounding properties, and we can't waive that 21-day period in terms of the application operator to audify this conditional use permit. So we can't change that 21-day notice or waive it or shorten it. That's right of the public. So that's one reason we can't hear that application is submitted
They've submitted their materials on May 7th, and I think they came in to start the public notice process a couple days later, and it was, at that point, they'd already missed the deadline.
And I just want to be clear for Dean that I didn't mean, I don't want to waive the public hearing. I just want to try to make this as seamless as possible, pending the final outcome. And so I would like an amendment drafted to allow for the conditional permit to go through the end of June.
That's what they're trying, yeah. To let you know that behind the curtain, we actually already had an amendment drafted because we figured there were a couple different options, and we talked about this with the sponsors. You could either have it terminate on May 31st or extend it, or again vote it down. We wanted to put the more impactful option in the first draft to make it very clear to the applicant that this was something that might occur. So they have clear notice up front from the very beginning that this body is considering an option which would not allow them to serve alcohol after the 31st of May. So-
Mr. Training and Mr. Croft.
Peggy, why did they miss the date? Didn't they have adequate legal counsel or what?
I mean, Mr. Coffey wrote me an email and said it was probably my fault. I didn't remind my
So they didn't have
so-
adequate legal counsel, is what you're telling me.
I don't know. I'm not sure. I'm not sure what happened. They certainly have competent legal counsel who has worked with them competently in the past, so I'm not sure what happened. They did not. Yeah.
Thank you, Dick. Mr. Croft.
Yeah, I guess I'll listen to the debate, and we serve in a quasi judicial on this, so always open to hearing it. But right now, I would be inclined to do it as unamended. That they should, and because I think what we've seen here on the alcohol side sort of mirrors a lot of the things that have been happening on their other permits and things. They just don't get done. As Mr. Trainee said, they have a very experienced in this process and in alcohol general attorney, and they miss this and other deadline, and there ought to be a consequence. I mean, we're not shutting down their entire business, but you can't serve beer until you get this fixed. So I just think, we talk a lot about the precedent that gets set, and I think a lot of other people that we have held to standards are going to look at us with this and say, why did you keep giving them when you told me? Yeah. And does it have anything to do with the fact that Dan Coffey represents? So both on the merits and the perception of it, I think we ought to say there are consequences.
Mr. Training.
I intend to vote for this one because you're right, they had 3 years. And I remember when they first came to us. Dan Coffey said, I guarantee you I will watch them. They will conform. Okay, they hadn't conformed in that amount of time, and now they missed the May 1st deadline. It's like, good heavens, who's in charge over there? So I intend to send this forward. And if they have to stop selling alcohol on that date, they stop selling alcohol. Maybe they'll warn. But you're right, Aaron, because if we let this one slip through, the next one that comes in front of us, they're going to say, well, you let this one go through. Why'd you do it?
Mr. Constantine.
Thank you, Chairman.
Yeah, I'm not going to speak to either one or the other, but just by opening this business and allowing it to operate, to let it through. This is a unique one-off thing, and so it started from the creation of it. In some ways it's the operator, but in some ways it's our own procedures. And
Yeah.
I know if we do move forward, I wouldn't support a permanent extension of the conditional use. I would support another kind of limited, so that he can once again prove up on his commitment to do the job.
I did last time.
I know, and then this then would be, you either do it or you don't. But I wouldn't be interested in granting a permanent conditional use because of all of the problems that we have seen in the record.
Yeah, so I'm going to editorialize for a second and give it to you, Mr. Peterson. I would just say that personally, and I wasn't on the body when this was originally approved, but I think this experience has, at least for me, sort of educated me on, I don't want to do this process again. This is consuming a tremendous amount of our energy, and like some of the finest public interest lawyers in the state, or public employee attorneys we have in the state are spending a lot of time on this. So if we want to do unique projects like this in the future, I think we should rewrite code to allow businesses like this if we want to do it, and not do it on this kind of ad hoc basis. We do want, I think we all want to have creative businesses in these parts of town, but I think we need to think about changing our code if we want to do that, trying to avoid some of these ad hoc situations. Although I acknowledge that more will come up, and sometimes they're unavoidable, but this has been a learning experience for me. Mr. Peterson.
Thank you, Mr. Chairman. And part of the discussion back 3 years ago was the fact that the location was in the east section of downtown, and that is an area that is ripe for redevelopment, we'll say. And his business plan was unique. I can think we can all say that we had never seen an operation exactly like that before in the municipality. And so we thought we'd give him an opportunity to prove it up and maybe someday build a permanent building over there if things went well. And so, I don't know, I haven't heard of any ABC violations, so he must be a fairly good operator. Have you heard anything, Mr. Constant, negative in your area?
He owes a lot of money to the city. He's not been paying to the city. I think there's a lot of debts associated with this one to the city.
Well, I just want to clarify before I go to Wisconsin. I don't mean this as an indictment of the prior assembly that allowed this to go forward. I think that it was creative at the time. Just seeing how it is played out, it has consumed more resources than I think is appropriate. And well, you couldn't have known that 3 years ago. That a lot of promises were made.
Right.
Mr. Constant.
Well, yeah, you could have known it 3 years ago because it ate up a tremendous amount of resources then. But the idea was, I believe, I was there for a lot of the process, was to experiment and see if this function works. And so it clearly is and easily to anticipate that it would be something that costs time and energy to get it right. And I think the planning department would suggest, oh no, we don't want mobile food trucks selling beer. And I think that that's the nexus of the question that we have here, if you separate it from the petitioner in this instance, but what the movement is. And so wading into the code and asking ourselves if we want to create like temporary structured liquor establishments is something that this experience will definitely advise us towards. So I think it's of value.
Sorry, Mr. Bussey.
Sorry, I raised my hand and you had your mouth full. So I think everybody's made some really, really good comments. And I want to go back to part of the reason we did this and the location we did this is because we were trying to revitalize the eastern part of downtown Anchorage. And part of the reason this is kind of a crucial issue to allow them to go through the full process, the public hearing process, before we take out a month basically of the summertime is because this is an outdoor patio. It's relatively close to the Saturday market and some of the things downtown, but this is their prime earning time and the draw for that area. So I am trying to make this not a punitive effort. Yes, they missed the deadline, but I remember in our last meeting when we discussed this, there was a lot of confusion among attorneys, what we could say, what we couldn't say, how the processes were going to work, what exactly we had to do, what exactly they had to do. And so I think because this was, I mean, we had discussions about should we just change code, but everybody was very skeptical about how it would look, how it should look, what lessons could we learn. So when we do look back at this from a historical perspective, we have to realize we are making a significant decision whether there are going to be instances and what parameters we should put on those limitations of mobile food carts having alcohol licenses. And we also have to go back and address the issue of sometimes it makes sense from a sanitary perspective to let mobile food carts hitch up to water and sewer. And that's something we've frankly fought the planning department on. I think from a health perspective, yes. I mean, they gave them a condition to meet. In order to get this license, you have to be able to hitch up. But because you're a mobile food cart, you can't hitch up. And so that was really the crux of what pushed the assembly into this realm, was one of those, is that particular checkoff. And so I'm not trying to give somebody anything. I frankly don't care who their attorney is. I don't care who dropped the ball. What I recognize is we have a business owner in the municipality of Anchorage on the eastern end of downtown district, which some will argue has been a derelict portion of their district. I think we have attempted to, from this administration's perspective, and even the one before, we have attempted to revitalize certain parts of the municipality to encourage business and to be supportive of new ventures, maybe creative ventures. And this one was ultimately the vision was to have a housing perspective or part to it. So my intent is not to permanently extend any sort of conditional use permit. I still find this until I get, the support from the downtown community council and from the downtown district member to say, yes, let's go forth and possibly do this permanently. I would be hesitant to do that. But all I'm suggesting is from just taking the whole totality of the discussion, I don't want to be punitive. I recognize this outdoor patio is truly going to be a seasonal issue. I mean, they might have it open year round, but people are going to use it in the summertime. I'm hesitant to take a month off, especially when I think it's achieved its goal. I know a lot of people that eat there, frankly, and I think it's been a positive thing for downtown. I'm not I'm not the member from that district, so I would rely on his counsel. But I think a 1 month extension just to get us through the public hearing I think it's reasonable. And you know, I personally don't feel it's necessary to come down as a hammer when we're trying to, you know, we have a lagging economy, and if we have a business owner who is shown to be a good business owner and partner in our community, I think it's not an unreasonable ask.
Thank you, Mr. Mbasi. So, Mr. Constant, and then I'd like Becky to, if she could, wrap up kind of what's going to happen on Tuesday and any other further advice she has.
Yeah, just speaking on behalf of the Downtown Community Council, their position was they don't object and they do defer to this body's decision, right? Because they have no objection, but they understand that there are issues afoot that have to be addressed. So they didn't come out gung-ho, but there were no complaints and there were no objections from a neighborhood perspective.
Thank you, Mr. Constant. Ms. Wynn Pearson, could you finish your presentation?
Certainly. So the next steps on Tuesday, this resolution will be under item 9 on the agenda, so you'll want to pull it if you want to consider amendment. We'll have an amendment prepared that would eliminate or extend the conditional use permit until the public hearing is completed. You all can consider both of those. Again, your options then would be vote to adopt it as amended, to adopt it as is, or to vote it down, in which case the conditional use permit expires as its terms as of May 31st without any further action. And then if you do vote to either approve the AR as drafted or to approve it with an amendment that extends the conditional use permit, either way, I'd recommend again setting a substantive work session to actually go into the application materials and the staff report and et cetera prior to the public hearing at the end of June, because I think this is going to be a complicated issue to consider.
So on that, and so I kind of was going to ask questions, basically a preview of that, and that is for Mr. Schutte as well, if he has any information on it. But you know, what substantive? So if they had fines, for example, they had to pay. You know, what are those kind of steps that they've taken? And then I'll say to you, Ms. Wynn Pearson, if we do pass this, please someone remind me, because we absolutely should schedule a work session in June contingent on us passing this.
Certainly.
So do either of you have comments on kind of the substantive progress that's been made by this applicant?
No additional comments beyond what you've heard from Ms. Pearson earlier about as the conditions have been raised or as the issues have been raised, the applicant has record history and their ability to respond to them. But I think that in the work session, one of the things that will be important, and Mr. Bosky alluded to already, is that this was very complicated to begin with. And to understand where you are today, it might be worthwhile to suffer through some history lessons of how you got there first, and that will certainly help at the work session. And then understanding how this business was first set up and what the terms were, the expectations were at the outset, and then telling the story, which is where you all come in, of how those expectations either were or were not met, will give you the fuller picture to have the final discussion.
I request a PowerPoint from Mr. Falk.
And I can speak a little bit more to the substance. The substance, I mean, we received a comprehensive application from them on May 7th, which addresses each of the concerns. I would say some have been addressed. There were some permits they hadn't gotten, they have gotten. Some things haven't been addressed. They don't seem to have much to report in terms of progress toward a permanent building on the site, and some things it's debatable. Sort of the general summary, but you'll get it's a lot of different points that you will get when you get the complete packet.
Okay, Mr. Train and Mr. Crawford, I think we'll wrap up.
This is a marijuana license would require all the conditions to be met before they open. I have concern we treat alcohol completely different. We treat alcohol, we treat marijuana.
That's the other way around.
Mr. Croft.
So without the amendment that Ms. Dombowski was talking about, what is the effect of isn't the effect of passing this the same thing as not passing it?
No, because it sets the public hearing date and it allows them on June 26th to actually extend their existing conditional use permit as opposed to having to come in and start the process from scratch and apply for a new one. So basically lets you take their existing CUP and either just extend it under the same terms or modify those terms. It's simpler, faster, cheaper for them, and allows them to potentially have a conditional use permit again 3 weeks after their first one expired, which would not be the case if you don't.
Unamended, pass or don't pass, they stop serving alcohol or should on May 31st.
Yes.
But it has different consequences in terms of restarting of the process, noticing a public
Yes, very
hearing, all
different
that.
consequences.
Okay, thanks.
Is this the only item in our packet related to AK Alchemist?
Yes, this should be the only item in your packet for this week, yeah.
I have a clarifying question.
Mr. Moss?
So Becky, can you reiterate specifically, not with the alcohol service part, but for the conditional use permit, if it lapses, what is the process? Do they have to start all over?
They start all over,
That's
yeah.
what you just said.
Yep.
So can you explain that? Because this, again, I think bolsters why I think it's a good idea just to pass an amendment for 3 weeks or a month.
Yeah, so if you don't approve this, and they just let the conditional use permit lapse completely, then they have to start from scratch, which I honestly don't know all of the nuances. I just understand from planning that it is significantly more complicated. They have to, go through the whole process of they do the pre-meeting, and then they do the community council meetings, and then they have to do, I think the requirement is now 2 community council meetings, and then a report, and then they go through to create the as-built survey, and it's just it's a significantly more onerous application process, a longer application process than it would be for them to just come in and submit the materials that we've requested from them on June 26th and have a public hearing before this body and potentially have a decision right then.
Okay, so to clarify, maybe I misunderstood then. So I understand that if we don't pass that, this is what happens. If we pass this saying that the conditional use permit expires in March, do they still have to start that process over?
No, that's what this does, is it starts the middle path. The conditional use permit expires May 31st, and then it allows them to, we've crafted it to say basically that you guys can retroactively revive it via amendment. It gives them that pass to just go through the amendment process on June 26th as opposed to starting fresh.
Okay, thank you.
Yeah.
Okay, that's all we have. We'll close this work session.